Trinidad and Tobago. This year, we did even better than last year, performance-wise, as it relates to serving the population. Mr. Paul would allude to this, that oftentimes we outside in the public and price smart, penny wise. People ask for Miss Joseph, they speak of Mr. McLean, they make us out because there has been such an impact with what we have been offering that the legal education and that term, as Mr. Paul would have coined, the democratization of law, which is just a fancy word for accessibility, has been achieved, and we're still achieving it. We're still doing it, present continuous, by these webinars. People thank us all the time for bringing law to their homes, bringing law to their hearts and to their minds to understand what is constitutionally their entitlement. So I thank each and every one of you. We are a very unconventional firm, but we are effective. And I'm very, very proud of what we've been able to accomplish in these short 3 years. All right, so without further ado, I want to go into what we wanted to discuss this evening. And Ms. 𝗟𝗲𝗴𝗹, and she didn't introduce herself, she didn't read her bio. So I will give you her bio because listen, she is soon to perhaps not be in her full-time capacity with us very soon. And my heart aches. Ms. 𝗟𝗲𝗴𝗹 is one of the best legal secretaries I have ever had. And you see, look, Ms. Joseph, yes, we've ever had the pleasure of gracing our halls. And we will certainly not find, I believe, locally, the competence, the integrity, and the efficiency of Ms. 𝗟𝗲𝗴𝗹. Her work ethic is admirable. Her acumen for legal understanding is astonishing. And it is a great loss. We understand the circumstances of which you have to leave us, but you are the legs we stand on, Mrs. 𝗟𝗲𝗴𝗹, and we thank you immensely for your contributions, for helping us to effectively and efficiently, in court, out of court, with the clients, everything. You know, we applaud you. I know we can't clap, but you see that we all feel the same way. Thank you.
I'm blushing. Thank you.
Yes. And her bio is that some of the people, some of the best legal associations, I would not call name, would have had the pleasure of having Ms. 𝗟𝗲𝗴𝗹. She's extremely experienced and has helped some of the best attorneys to ever pass through Trinidad and Tobago. And we really, really thank you for your contributions to the fraternity. So I will let you lead. This is your night. You will host this evening's webinar and sort of just kind of recap some of the things that we've touched on. I know that you're intimately acquainted with each of us and you know our strengths as it relates to practice. So I would let you take the lead in some of the things you perhaps wanted. I know that we have preempted questions that Ms. Tasha Rochford, our marketing manager and admin who manages this webinar, she would have given us. Do you have access to those questions, Ms. Lopez?
I don't think I have those questions.
These questions, right. Send them to you. And so you could review what you would like to bring up. Yeah. Because we did ask you guys to access questions and we're letting you all take the lead this evening.
I've got it. Okay. So let's do that. So thank you for allowing me to lead today's discussion. So I think early on we hit land matters, and so I think one of our first questions is actually very interested in a deed of gift as an option. What are the pitfalls, pros and cons, etc. of a deed of gift?
Nice question. Very, very simple. Well, it's conveyancing and deed, so I will answer. A deed of gift, as the name would suggest, is a gift that you're giving someone by virtue of a registered deed or registered title. You can also have a memorandum of gift where the parties to such a document, they are referenced as donor and donee. The person gifting is the donor, the person receiving is the donee. Instruments of title like these, they carry stamp duty. They are not exempted from duty. However, there is no consideration price, meaning that there is no selling price involved and the transfer is immediate. Save and accept if there is a clause included that you are to retain a life interest as the donor, and then after your death, that the gift activates. If there is no such clause, the gift is immediate and the donee will be the owner after the execution and the registration of the instrument. Pros and cons, I would let Ms. Joseph answer that if she would like, to discuss some of.
I related to the same deed of gift?
Yeah, I think we need pros and cons because people often ask, should I gift it now or leave it for them in my will?
I'm going to answer, I don't want to say in a rather convoluted way, but by giving a very recent example. Very quickly, brother and sister own property jointly. Brother does a deed of gift and gives his half share to his son. So the property is now owned by his son and his sister. Sister dies, but sister has no husband. She has no children. Brother goes to an attorney who is now gifting to him. He's now gifting to his son the sister's share. But the attorney is unwell, so he comes to me to complete the work. I said, but you have nothing to give to your sister, to your son. You already gave your son your half share him. But remember, I have a life interest and my son getting it when I die. So he didn't have it yet.
No.
First time I said, but the thing is, he has already gifted it. So even though he's still, but you see, so I think, Miss Danielle, that is a misconception of what we probably never really explored. So he comes to me thinking the fact that he's still alive, the gift hasn't passed, which is true.
True, but relative to his life only.
However, legally, he has already done certain things to pass it. So he cannot behave as if it is still his own without revoking what he did.
I'm not going to say unless he revokes that gift, that he will not be able to revoke the gift without the consent of the donee still. Because, all you have in your life at that point. This is very interesting, Vivian. Very interesting.
I tell you, and I don't think we ever explored it. So when it came
to this, very interesting.
I said, we have to bring it here.
You have to bring it here. Because you see, a life interest is personal to you and it's not transferable. And when you retain a life interest, that is all that you keep. Your entitlement to gift has already gone to that person who gifted. But if you would like to change your mind, so to speak, or you would like to mortgage, or you would like to do anything, you have to include the party who that decision is going to affect. Because that's why I love law. It's very common. Let's reason it out, right? You've made this person now a party to this deed. Therefore, you've given them interest. Anytime you want to touch their interest, you have to tell them.
But
you see, but this was a layman. We said he has a life interest. So he said, Miss Joseph, I ain't dead.
Yes.
So I still have my interest.
It's just still there.
Interest gone. It's gone. And your interest is with you for your life. Yes, that's why we use the term subject to a life interest, because both interests is restricted when you create that sort of arrangement. The life tenant's interest is restricted to the knowledge or the interest of the person after they die, which is the donee, and the donee's interest is restricted by the life of the life tenant. So they have to do everything together. And that is why if you want to mortgage the property, one person cannot go by themselves and let me use the word, one person ought not to go by themselves and do it, and it ought not to be a registered transaction before the Registrar General. I use that word ought not, because we know we live in Trinidad and Tobago where miracles and many things happen. So I would say ought not to happen.
Nice. Thank you so much. Thank you so much for going into depth with that, Ms. Joseph, and considering what really a life interest means. That's something for us to think about before we go ahead and do those deeds of gift.
But you know, and the person who drafted it is an old, seasoned attorney, you know, and because he fell ill, and the person came to me. And for me, because I know the attorney, so I'm ready to
sign. Yes,
so it falls right there.